From Dominion Voting Systems' $2.7 billion defamation suit against Fox News, to California House Representative Devin Nuñez's libel suit against a self-styled parody Twitter account, to former President Donald J. Trump's libel suit against the New York Times. Defamation has certainly been in the news lately. So what is this legal concept? What elements must a plaintiff prove? How may those elements differ when the plaintiff is a private person versus a public official or public person? What defenses are available to a defendant in cases like this? Well, stay tuned. The videos in this playlist provide the answers to each of those questions. Welcome to Roman Matter. This video will explore defamation law from the point of view of a private plaintiff. This video is for educational purposes only. It is not legal advice. And with that, let's get to it. This lesson's purpose is to give a basic overview of U.S. defamation law by examining it from the private plaintiff's perspective. We will proceed as follows. We start with a lesson introduction, covering defamation's purpose and a bit of history, before exploring the definition of defamation. Then, we cover each element in depth before concluding. So let's begin. Defamation law exists to protect one's reputation. The doctrine is one of the oldest in existence. It dates all the way back to the Sumerians. It's mentioned in the Bible, and it's even found in the Salic Codex of the Franks. In England, after the Norman conquest, engaging in defamation could result in the cutting out of the defamer's tongue. It was also in England where the distinction between libel and slander first began, namely that libel is written defamation or otherwise captured on a medium, while slander is spoken defamation. American defamation law is largely the work of state legislatures. Many states no longer recognize the distinction between slander and libel, while states like California still do. The doctrine applies to both private and public individuals, though defamation of a public person or official requires the satisfaction of additional elements. The 1964 U.S. Supreme Court case, New York Times v. Sullivan, is perhaps the most famous court case involving defamation. This case established that a plaintiff who is a public person or public official must prove two more elements in addition to the four comprising private defamation. But we will explore that aspect of defamation law in our video focused on public officials and person. So what is the civil tort of defamation? Let's start digging into the concept itself. The Restatement Second of Torts, section 558, lists the elements composing defamation. It states that, to create liability for defamation, there must be A. A false and defamatory statement concerning another. B. An unprivileged publication to a third party. C. Fault amounting at least to negligence on the part of the publisher with respect to the act of publication. And D. Either actionability of the statement irrespective of special harm or the existence of special harm caused by the publication. That's the restatement's definition, but let's take a look at the so-called Prima Facie definition of defamation. To make a prima facie case for private defamation under the common law, a plaintiff must prove the following elements. 1. The plaintiff must show that the defendant engaged in defamatory language. 2. The defendant's defamatory language was of or concerning the plaintiff. 3. The defendant engaged in a publication of the defamatory language to a third person. And 4. The plaintiff's reputation was damaged. If the plaintiff is a public person or a public official, then he must prove two additional elements. 5. The plaintiff must prove the falsity of the defendant's defamatory language. And 6. The plaintiff must prove the defendant's fault. Elements 5 and 6 are covered in our video concerning defamation and the public plaintiff. For now, let's take a look at elements 1 through 4 in depth. To be clear, under the common law, defamatory language can only be directed toward a living individual. A dead person cannot be defamed. However, a defendant can direct such language towards corporations, partnerships, and unincorporated associations. For the latter, think of things like professional associations, HOAs, amateur sports leagues, and the like. Regardless of a plaintiff's status as an individual or a corporate entity, the first element that it must prove is whether the defendant engaged in defamatory language. So the question we must answer here is this: what is defamatory language? Black's Law defines the word defamatory when used as an adjective describing a statement as one tending to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting a person's business. The Restatement Second of Torts, Section 559, defines a defamatory communication in the following way, stating that a communication is defamatory if it tends so to harm the reputation of another as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. In short, it is language that harms one's reputation. Now, it may be helpful to define what is meant by reputation. Black's Law defines that concept simply, stating that it is the esteem in which a person, that is the plaintiff, is held by others. But frankly, reputation is a nebulous concept. For the purpose of defamation law, a reputation is something owned by each person, and its protection from harm is defamation law's primary purpose. The second element a plaintiff must prove is whether the defendant's defamatory language was of or concerning the plaintiff. This requires the plaintiff to show that a reasonable reader, in the case of libel, or listener or viewer, in the case of slander, would recognize the defamatory statement pertain to the plaintiff. In many cases, this is straightforward. The defendant uses the plaintiff's name in connection with the defamatory language, or the connection between the defamation and the plaintiff is otherwise so concrete that a reasonable receiver of the information would impute the defamation to the plaintiff. However, there are instances where the defamatory language is not so straightforward, but nonetheless can be imputed by a third-person receiver to the plaintiff. In those instances, the plaintiff must introduce extrinsic evidence showing how a reasonable person can connect the defendant's alleged defamatory statement to the plaintiff. This concept is called colloquium. Black's Law defines the concept as the offer of extrinsic evidence to show that an allegedly defamatory statement referred to the plaintiff even though it did not explicitly mention the plaintiff. In this way, innuendo that does not explicitly name the plaintiff can be classified as a defamatory statement. The third element a plaintiff must prove is whether the defendant engaged in what's called publication. This means the defendant communicated the defamatory statement to a third person. Black's Law defines publication as the communication of defamatory words to someone other than the person defamed. It's fairly straightforward. That third person must have also understood the communication's contents. The most common illustration of this aspect of the requirement looks something like this. X wrote a libelous email to Y about Z's conduct in business, but did so in Italian. However, Y only speaks English and a bit of German, and so obviously she couldn't understand the email's content, and so no defamatory communication took place. This is something of an oversimplification, but I think you get the point. Per the Restatement Second of Torts, Section 558, subsection C, publication requires fault amounting at least to negligence on the part of the publisher. From this, we can infer that the defendant must either have intended to make the communication to a third person, or at least conducted himself negligently when doing so. Remember, it is only the defendant's intent to spread the information to a third person, to publicize it, that matters here. The plaintiff is not required to show that the defendant intended to defame him, only that the defendant intentionally or negligently publicized the statement to a comprehending third person that is at issue. The fourth element a plaintiff must prove is whether the plaintiff's reputation has been damaged. This sometimes turns on whether the defamatory statement was slander or libel. Let's take a closer look at the distinctions between general and special damages. In libel cases, general damages, also known as presumed damages, are, as the name suggests, presumed by law. This means the plaintiff is not required to plead or prove special damages. In essence, if the defendant made the libelous language, it was of and concerning the plaintiff, and publicized to a third person, the court will presume the language damaged the plaintiff's reputation. The policy behind this result is that written defamation is thought to be more concrete and thus more harmful to the plaintiff's reputation, hence the lack of a requirement of special pleading. Special damages, in the context of a slander lawsuit, refers to pecuniary losses to the plaintiff resulting from the defendant's defamatory language. Think of instances where the plaintiff lost employment, clients, or business because of the defendant's slandering of the plaintiff. Generally, slander or spoken defamation requires pleading and proof of special damages. This is in contrast to libel, because slander is spoken and considered less concrete. However, if the slander fits into one of four categories, then special damages are not necessary to prove. Let's look at this concept next. Slander per se is a spoken defamatory statement falling within one of four categories. If the slanderous statement at issue pertained to any of these four categories, then the plaintiff need not plead nor show proof of special damages. So let's take a closer look at each of these four types. Traditionally, under the common law, this category referred to crimes of moral turpitude. Modernly, a defendant may engage in slander per se if they impute to another the commission of any crime. For example, under Section 46, subsection 1 of California Civil Code, slander is a false and unprivileged communication, orally uttered, which charges any person with a crime or having been indicted, convicted, or punished for a crime. A spoken defamatory statement that adversely reflects upon a plaintiff's ability to practice or conduct himself within his trade, profession, or business falls within this category. The statement must contain a connection between the plaintiff and his business. For example, a statement that a bank teller is a thief implies he cannot be trusted with money. California Civil Code, Section 46, subsection 3, provides an example of this in state statute. That section provides that spoken language which tends directly to injure a person in respect to his office, profession, trade, or business, either by imputing to him general disqualification in those respects which the office or other occupation specially requires, or by imputing something with reference to his office, profession, trade, or business that has a natural tendency to lessen its profits. The common law limited this category of slander per se to venereal diseases and to particularly feared contagious diseases like leprosy. As an example of state statute, Section 46, subsection 2 of the California Civil Code provides that spoken language which imputes to a person the present existence of an infectious, contagious, or loathsome disease is considered slanderous. Under the common law, slanderous talk regarding unchastity was only applicable to a female plaintiff. However, in some states, and using California as an example once more, this slander can apply to all persons. For example, Section 46, subsection 4 of the California Civil Code provides that spoken language which imputes to him impotence or want of chastity is slanderous. Keep in mind, the use of the pronoun him is read as applying to all persons. Okay, this lesson's purpose was to give a basic overview of U.S. defamation law by examining it from the private plaintiff's perspective. We started with an introduction covering defamation's purpose and a bit of its history, before exploring the definition of defamation. Then, we covered each element in depth before wrapping things up. Now, when defamation involves a public concern, official, or a matter of public interest, there are additional elements that the plaintiff must prove. Take a look at that video next in the playlist. For defenses to defamation, for both private and public plaintiffs, look to that video on that subject as well. It's the last one in this playlist. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.